Lordship, for listing. This is relating to that insanity case, Lordship. I filed the IA on 16/11/22.
What case? Which case?
Lordship passed a judgment, and then thereafter,
In jail, some direction was given to it. This of the report has come.
Oh, I see. Oh, I see.
so
Okay.
for tomorrow, I'm mentioning Lordship.
Tomorrow.
It's an IA, Lordship.
IA for what? IA for what?
I for taking into consideration the report from the
Okay, tomorrow.
highly obliged, Lordship.
Okay, yes, next.
Daily list for orders item 1.
Lal. Yes, what to do, Mr. P. Kotoki is there? Yes, yes, Mr.
May I please, I've gone through the record, my lord. There is another criminal petition which was also.
Yes, Kolita, you are there, no? You are
Sir,
appearing in
I'm
this case.
appearing, I'm
So, what is to be done today?
Lordship, that will be heard. Lordship, today.
It will be heard, no?
Yes, Lordship. Yes.
Okay, then we'll fix a date for hearing.
Actually,
Yeah.
what happened, my lord? A co-accused, my lord, had filed a criminal revision petition, my
No problem.
before the High Court bench, and that was allowed. An order of congregation was set aside. Justice Nelson, the order is there, my lord. It is
Doesn't
enclosed in the-
matter, there's no single, let the single judges keep doing whatever they want. We are not bound by the single.
I
Judge. We'll
understand.
decide what is the,
Yes, Lord.
because we can't comment on that.
And I understand. my-
As far as like Lordship cognizance is concerned, Lordship, whether Supreme Court decision is there, so like I'll place this.
I think, let us hear it then.
Yeah,
Whatever,
yes,
no
ma'am.
problem. Like, because see, there is no issue. Without, when can you,
Your
please?
lord.
Any date, yes, both of you should be ready, that's
Yeah,
why I'm
I
saying.
understand, my lord.
But yes, give a convenient date. Give a convenient date. Well, it should be decided whatever Mr. Kolita has said, we'll decide as per the Supreme Court. Clarify it if there is any doubt.
Sometime in the first week of January also.
First week of January. Aaj ki tarikh. Today is
8th of December.
8th of December.
It can be done earlier also, Lordship, I don't have any.
So lordship, but
At your convenience, Lord. Okay.
if time permits, it's small matter actually.
A small matter, next week or, because you have already Supreme Court judgment with you.
Yes,
Yeah,
yes,
yeah,
yes.
yeah. There is a settled law, also, but
কি কি আছে ফিক্স কোনো ফিক্স আছে নাকি কোনো ডেট হেভি হ্যাঁ নেক্সট উইক Nineteen. Let us make an attempt on 19, sorry, 20, no? 20 December.
Yes,
Yes, ma'am.
20.
If it is not very heavy matter, we can,
yes, yes, short matter.
20.
20, no? On joint prayer, list the matter on 20. And Mr. P. Kotoki, learned amicus, as well as Mr. Kolita, learned additional advocate general of Mizoram. Any other representation is not necessary.
No. Obliged.
Yes.
Item number 2 for orders.
What is this Nazrul Haq? What is this IF for what? Yes,
I
madam.
have for my lord,
Ah.
delay of condemnation for 54 days, my lord,
54 days.
my lord.
For what?
For my lord, dismissed for default, my lord. On that period, my senior was not able to there, my lord.
Yes, default. Yes. What is this matter about?
Lordship,
For an-
this was dismissed for default, lordship.
Where? By which court? What is the order? What is the impugn order?
Impugn order, my lord, I have annexed in this case, my lord,
Page number?
not IA, my lord, miscase, my lord.
What is the miscase?
Miscase,
Miscase
my lord,
10.
page number 15, my lord.
What is the order? Page number
15, my lord.
15. Special division bench mane ki. What is this special division?
My lord, that is a hearing list, my lord.
Oh. Okay. Yes, Mr.
Lordship, yeah, no?
And what is your name?
L Wajida, my lord.
Miss S. Wajida Ahmed.
L Wajida.
L. Wajida. Hard Miss L. Wajida. The present application is in file for restoration file for condoning the, what is the restoration? I miss case 10. Miss
My
case
lord.
10 is the restoration.
My lord.
The application for condoning the delay of how many days?
54 days, my lord.
54 days in filing a condonation application, sorry, restoration application. File restoration application for restoration of the writ petition number 6837 which was dismissed for default on 3/8/2022. They have been submitted that the absence of the council was due to council, no?
My lord.
Council was due to his illness, huh?
My lord.
As he was undergoing medical treatment in Rahman Hospital, Guwahati, downtown hospital, Guwahati, and also in CMCH, Vellore. As he was suffering from kidney and urinary problems, resulting in a non-appearance on behalf of the petitioner. First of, having heard the learned counsel for the parties were inclined to allow this application to condone the delay. First of, next, we have passed an order today in IA 3565 of 2022 condoning the delay of 15, condoning delay in filing this miss case. We have also heard Mr. Learned Counsel who has not raised serious objection to some accordingly. The miss case allowed, the petition will stand restored to the and be listed in the stage in which it was listed. Both separate orders.
Oblige, your lordship.
Yes.
For
next.
hearing, item 3.
Moinuddin Ansari, yes, what is this hearing? What Ansari?
May please your lordship. My lord, here, my lord, basic, my lord, contention, my lord, is on the inquiry report, my lord.
What is the problem with inquiry?
My lord, that was very mechanical inquiry, my lord.
You have
Nothing was
perused, no?
Yes, my lord.
In the inquiry report, what is written?
Nothing.
What do you mean by nothing?
Kindly say, my lord.
Out of nothing, something has been created.
Yes, my lord.
Out of void. Only God did that.
Yes, my lord.
God could do that. Out of void, this universe was created.
Yes, my lord. But we have tribunal has created, my lord.
Huh?
Page number 47, my lord, kindly.
Please.
It is just-
Moinuddin,
my lord.
name of constituency, LBO की नाम नो पत्रो देखवा ना पारिले हैं, something like that. Noarile. You fail to produce any document
Nothing, my lord.
because you are not
The
an Indian.
inquiry officer never visited the house of the petitioner, my lord. Never visited.
He says no parile, you cannot, when asked, you do not.
Nothing, my lord. He has never visited, my lord. Can you see nothing? And even, my lord, where from he had come, you know, which stream he was referred, nothing there, my lord.
Because they can't tell you, no, because they are also confused, because you can't produce, then you
How I can produce, my lord? They have never approached me, my lord. And he is a police personnel, my lord, serving from 1997, my lord.
have.
That LBO,
He is a police
LBO was,
personnel, my lord.
came before the tribunal to depose.
LV also came, huh? LV also came.
He has called for lordship.
He was cold.
Yes, sir.
Oh, I see. And what was the latest?
In page 40 lordship,
What is the name of that?
Dilip Kumar Pathak.
Dilip Kumar Pathak. Let us see in the original record. Apart from this, any other submission?
My lord, he was, she had,
Dilip Kumar Pathak, huh? Let us see. Dilip Kumar Pathak. He was examined.
Yes,
yes,
sir.
Huh?
Yes, sir.
What is his statement?
At, page 40. Page
Dilip
40
Kumar
lordship.
Pathak, I was appointed.
Second pedal, third pedal.
I was appointed by Deputy Ishwan. I visited village Moira Mara and made door-to-door investigation along with the Gaumbura and visited the house of OP Moinuddin. I asked the OP to show documents related to his nationality, but he could not produce any such document in support of his nationality. Thereafter, I served a common notice and hang in a public place against all the suspected D voters to produce document in a period of 15 days. However, on expiry of 15 days, OP failed to submit any document. Therefore, I took the signatures from Gombra as witness and prepared a report and submitted before the ERO for taking necessary. But you did not cross-examination, you didn't do anything.
What is the governor's signature, my lord? I have didn't find anything on the inquiry.
Oh, but did you question that, say that Dilip Babu, apni to aha na hai.
What,
Did you make any cross-examination?
my lord, that is, that is only on the, my lord, opinion, my lord.
Oh,
He was even-
his statement was
he-
recorded in the tribunal. He came in the tribunal.
My lord,
Then he should have asked Dilip Babu, apni keti haisil. Aha na hai apni to. Any misa kota koise. If you ask this question, cross-examination is necessary. If you want to
My lord,
dispute. If you don't ask anything, then it's presumed to be correct. Uncontested statement, evidence of a witness. If the witness evidence is not contested, uncontested, then what will happen?
my lord, whether, that-
Unreported.
whether
if-
that, OP, that Dilip Babu's statement is there, my lord.
Dilip Babu's statement is here. You will see for yourself. It was recorded on 17 February 2017. When was you were there on 17 February 2017?
My lord,
Asile naki nai.
no, my lord, that is, probably here appeared before the tribunal, my lord.
Oh, but he has to appear before you
But,
also.
my lord, I am the police personnel, I am serving, my lord. And while he had come, I don't know, I did not know, my lord. I have collected the electoral roll, sorry, my lord, inquiry report.
Oh, when his statement was recorded, you were
My
present or
lord,
not?
Inquiry report, my lord, kindly see the inquiry report.
Oh,
my
you,
lord. And he may submit anything subsequent, my lord.
oh, why you are asking, you are arguing before this court. You should have asked Dilip Babu.
My
Aapne
lord,
misa kotha koise?
my lord,
No.
he definitely support his claim, my lord.
Oh,
My lord,
you have not done any criminal case or what? Any civil law? You have not,
no, my
you have
lord,
not done any
no.
cross-examination of witness.
No, my lord.
And then, what is the purpose of cross-examination? Cross-examination of witness is to test truthfulness of the witness. You ask question. That's why we get shaken,
lord,
not second,
My lord,
unreported.
in the,
You just keep quiet.
in
If Dilip Babu comes and said this hello, I asked him and he did not say, and you keep quiet, that means it's correct.
my lord, in the tribunal, normally, my lord, those opportunities are not given to. for
You
court-
say that his evidence was examined in my absence, then this evidence is useless then.
Yes, my lord.
What, yes, what, yes. You are not saying anything, we are saying. Come prepared, mister.
My lord,
You see this document, on the 17 key say whether you are not, you come prepared. These are factual matters. You have to convince us that when the statement of Dilip Babu was taken, you are not there.
my lord.
So I don't know what statement he was given in tribunal. So this cannot be acted upon.
Yes,
Then
yes.
we'll consider, otherwise we cannot. Arey Baba, come prepared, this is a hearing matter,
Minor,
this is not a
minor.
motion. Motion to be also come ready so we can help you, but
My lord, my
hearing,
lord.
sorry, come
Minor,
prepared. These are, don't take it so
Yes, yes, my lord,
easily.
my lord.
You are dealing with the citizenship of a person. If you are
My
saying
lord,
that you are Indian, you
yes,
must
yes, my lord.
properly defend yourself.
Yes,
Hmm,
my
hai
lord.
na?
My lord,
Come
actually, I did not that he was examined, my lord.
Huh?
Actually, I had not knowledge that he was examined.
So see this record.
My lord,
Eh,
my
na? Mister, what is your name, Mister?
Ashok, my lord.
SOC is permitted to go through the original records before a tribunal. You see for yourself,
My
his
lord,
statement is there.
My lord, my lord.
Because that is important.
Yes,
Because
my lord.
you are relying saying that his LVO report is not correct. And his LVO has himself came to the tribunal and he said, yes, I went door to door. And he did not produce, he could not produce.
My lord.
So all those things, these are not very, yes. Next.
After vacation, my lord.
Yes, after this. Yes, Moinuddin.
Item number 4,
All right.
Moinuddin. Yes, tell us, Moinuddin, what do you want? What do you want, Moinuddin? Tell us.
Lordship, in this case also, Lordship,
Huh.
the inquiry part is it's really defective, Lordship, but it is not like that the person was examined, Lordship. But Lordship may kindly pay the inquiry report, Lordship. This is totally blank, Lordship. And Lordship, I perused Lordship once, Lordship. There was Lordship, another mark is Lordship, that is given the person was absent. And so no documents could be produced, Lordship. Then person is absent, but his letter is cut, Lordship. There is cut mark, Lordship. And if it is correct, Lordship, then Lordship, this judgment of Amina Khatun and Muslim Udu will cover this case, Lordship. This situation, Lordship.
Moinuddin
Yes, Lordship.
could not be ascertained, not furnished
Lordship, there is a cut mark, Lordship, in between this cut mark.
What
there
cut
is a
mark?
person- Yes, Lordship,
What
I'm
cut mark?
cutting, Lordship.
See, what
There is
cutting?
the Lordship, the person could not, person was the.
The
present.
person was found absent.
Yes, Lordship.
Hence, documents produced during verification.
Lordship,
No documents produced verification.
the person was found absent means Lordship, there is not correct Lordship. At least Lordship, he could not enquire me Lordship. And Lordship, that from the same document, same phrase, Lordship, another inquiry Lordship of similar person, Lordship, my neighbor. There is the mark of person is cutting is their Lordship. I can put it like no Lordship.
Once, but then in the tribunal, there was a full-scale inquiry. Assuming that it is wrong, they did not do properly. Now, we have been given all opportunity before the tribunal to produce, isn't it?
Yes.
Then what is your,
Even the Lordship, the basis of inquiry Lordship, that should be their Lordship. There is the
see,
fine-
you
yes.
see, in case of ex parte or something like that, we may throw out on the yes, close on the ground, yes, there was no proper inquiry held.
Yes.
But even in spite of no proper inquiry being held, you had all the opportunity to defend yourself before the tribunal. Before the tribunal, what did you say? What is your,
The tribunal also.
at least in the tribunal, you had all the opportunity to produce the documents.
Yes, Lordship, that is correct Lordship.
Then in that
But
case, what
even
is
the
still,
Lordship, where is the basis is not, basis is not correct Lordship. On that point Lordship, the honorable court already, Lordship, some discard the matter Lordship in Amina Khatun's case Lordship. There is the exactly similar in my case Lordship, may only peruse this judgment Lordship. There is the
no, but then, correct, violation,
Yes, yes.
correct, violation, if these are also one of the reasons we set aside, but then if we have been given all the opportunities and you cannot, you saw FP case erroneous, baseless, when you born, brought up.
That is correct, but that finding is in that cases also Lordship, the tribunal Lordship already decided the matter Lordship, even then Lordship, the court Lordship took that view Lordship.
Okay, then we'll hear this defective, no, we'll hear defective. I think the same earlier case also.
This judgment
defective.
cover Lordship, Muslim model paragraph 97 and 98 Lordship, Amina Khatun judgment Lordship. Lordship, if they have any objection Lordship, they can raise that now Lordship, because the issue is Lordship, it cannot be sensed.
See, correct.
Lordship.
Suppose we set aside this. Okay, go for a fresh inquiry.
Yes, Lordship.
Then what happened to the inquiry which have been held in a Borpeta tribunal? We were also participating, you have produced. You file evidence, documents also. So you have to come. If we see that, yes, your document has not been properly appreciated, that can be a ground, additional ground, that the inquiry was not properly held. But if you could do everything, then you come back, no, inquiry was not done. That is a problem also.
Yes, there is.
If
some
you say
evidence
yes, if we see that the tribunal has not properly proceeded, then that can be additional ground. But in this case, you have been given all the opportunity.
I have also availed my opportunity, Lordship, and I have, Lordship.
Do you have anything to say on merit? Do you on merit
Yes, yes.
about that also?
I have
On
also
merit?
merit, Lordship. Merit, Lordship,
What is the basis? Tell us.
Lordship, my parents' name, Lordship, grandparents' name, Lordship, they are.
Who were examined in your case?
My father, Lordship.
Your father had
Father's
come.
examined. Yes, Lordship.
The father evidence, let us see, what is your father?
Yes, father's statement, Lordship, there is in the.
What is the name of your father?
Abul Kashem.
Abul Kashem. Okay,
Lordship,
let us see.
Kashem,
Abul
yes,
Kashem.
Lordship. Lordship, in that
Many-
position I have annexed in the initial affidavit, Lordship.
Kasem Ali or Abul Kasem?
Both are Lordship, one, there was a Abul Kashem and others are Kashem Ali, Lordship. Both are there, Lordship, one person, Lordship.
I don't know.
Yes, Kashem Ali, Abul Kashem, Lordship, this is the Lordship.
My lord, I need to go through the record. Lord.
Go through you. See, the problem is they see you change your name, so Abul Kasem, then Kasem Ali.
Lordship, the main name is Kashem, Lordship. Abul is title and Ali is also the title, Lordship. This is the only main name is a Kashem, Lordship. So Abul, Lordship, is the title, Lordship, and Ali is also the title, Lordship. So Lordship, Kashem is the main name, Lordship.
More name Kasem Ali. Moi Diolit,
Devoldi, Lordship, Devoldi.
Diolit Thako. দ্বিতীয় পক্ষ নুমইন্দুল মোৰ ল'ৰা হয় মই 1970 চনত প্ৰথম ভোট দিছো মোৰ পিতাৰ নাম মৃত আছমাতুল্লাহ
Asmatullah, yes, sir.
মোৰ পিতাৰ মৃত্যু চনৰ পিছৰ হৈছে মোৰ নাম মৃত মাৰ নাম মৃত
Aziron.
আজিৰণ
Zamiron more Hotma Hoy.
Jamiron more.
হতমা, that is
Sorry.
stepmother.
Statement.
মোৰ
No.
মাৰ মৃত্যু হোৱা 25 বছৰ মান হৈছে আৰু মোৰ হতমা জমিৰৰ নেচা জীৱিত আছে। আবু বকৰ সিদ্দিক মোৰ ডাঙৰ ভাই হয়। মোৰ ককাৰ নাম শৰদ্দিন। Only this much is the cross examination lordship, but the tribunal lordship, though the fact is recorded here, lordship, there is.
What did the tribunal say?
Lordship, tribunal says lordship, many things is lordship.
Oh, many
Yes.
things, we don't want
Yes.
to, only about this.
Basically, lordship, the regarding voter list of.
No, what is the DW two? What did the tribunal?
DW lordship two rejected lordship on the ground lordship, said that lordship, he could not disclose the, he did not disclose the other names of the voter list lordship.
Hey, Baba, then if Mr. Sharma, unless you ask, then if you say Nam Kok, if you say no, I don't know, then okay, you cannot disclose. But if you don't ask, then how
Don't
can
ask,
you
yes,
disclose?
lordship. Never ask lordship,
It should be asked. If you fail to disclose, then you can say yes.
yes.
He's a fake witness. What do you call? Procured witness. Ki koi criminal in criminal term, trial ki koi these kind of witnesses, stock witnesses. Bringing.
Lordship, that is also.
Then what about who is this CW1?
There's a Gaura lordship. The Gaura also says lordship that he.
Read.
Lordship, I have annexed in the edition translated part of lordship. The Saiful Islam Gaura lordship. He says lordship, মই কোৰ্টৰ পৰা সমন পাই আহিছো। মই 2003 চনৰ পৰা গাঁওবুঢ়া হৈছো। মই পশ্চিম দেৱলদি, কয়াকুছি গাঁও, কয়াকুছি পাথাৰ, পাথালিয়াপাৰা আৰু বৰহাওৰা গাঁৱৰ গাঁওবুঢ়া। মই 5খন গাঁৱত মোৰ জনসংখ্যা কিমান আছে মই নাজানো। মই কোনো ধৰণৰ ৰেজিষ্টাৰ মেইনটেইন নকৰো। মই আজি মইনুদ্দিনৰ হৈ সাক্ষী দিব আহিছো। মই মইনুদ্দিনক 25 বছৰ ধৰি চিনি পাওঁ। মইনুদ্দিনৰ পিতা জীৱিত আছে। মইনুদ্দিনৰ মাক 3 জনী। মইনুদ্দিনৰ মুঠ ভাই ভনী 16 জন, কিন্তু মই সকলোৰে নাম ভালকৈ নাজানো। এক্সিবিট 1 মই দিয়া প্ৰমাণপত্ৰ আৰু এক্সিবিট 11 I1 মোৰ সহি, এইটো সত্য নহয় যে মই মিছা সাক্ষী দিব আহিছো। Lordship, Gaura also know since 25 years that he is the son of Abul Qasim or Qasim Ali lordship. Lordship, this must be enough lordship. And how much lordship do you want? Lordship, speaker is off lordship now. Speaker is off.
DW2, what is the observation by the tribunal DW2?
Yes, lordship, that observation lordship.
And who is this Kanchan Bibi?
Concern is my cousin sister lordship, and he got Indian lordship.
Cousin sister?
Yes. So lordship,
Anyway,
he also produced the document, same document lordship. My grandpa is same lordship.
Because earlier, it was.
Grandpa, her grandpa, my grandpa is same
Now they
lordship.
have shifted to Bhagwar, it is Borpeta. So that is the finding. DW also face 50 of the.
it is surprising DW2 also has not clarified a vital fact, that is whether his paternal family shifted from village Fafanga part Gwalpara to village Poschim Dioldi. Where is DW2 evidence? In chief, DW2.
Chief lordship is. His lordship is
Okay, regarding.
Page 43 lordship.
Said your mother, he has not said mother. He will be the about the right children.
So lordship, another fact will be lordship.
But did you mention anything about the shifting in your
Lordship,
evidence?
that is, Lordship, that
Not
is, of
mentioned.
course, there is no
And
doubt,
then?
Lordship.
Otherwise, see, Gwalpara, then suddenly Julli, arey,
And there are name and ST is also there, Lord.
But that is the border area Lordship, that Golpara is there and the Lordship Borpara, the present city is the dear Lordship. That's
oh, you
why-
have to mention there also,
Yes,
no?
Lordship,
I
that
was
is
in
of course.
Gwalpara, then I shifted there. That is why.
Yes, yes, yes.
That
of
is
course.
why the tribunal say you are, that Gwalpara is a different fellow.
Lordship, another fact, Lordship.
The
The
names
at
are
least,
so
Lordship,
same, similar
that,
name.
if the travel Lordship put and mention in the Lordship opinion Lordship, then he can also Lordship ask in the that time inquiry Lordship. Because inquiry power is totally upon him Lordship. He can ask any question Lordship. If there is any such doubt Lordship, but government is not co-certain about Lordship, but he has the power Lordship. He could have asked Lordship that why this document is from two place. Definitely, person when a person given two documents of two places, Lordship, meaning their Lordship, they have come from one place to another place. Lordship, that is meaning their Lordship. But at least Lordship, they also could have asked Lordship this question also. Lordship.
If your Lordship.
And only this must
And
Lordship,
nineteen
cannot be
seventy-one voter list.
the main
all
ground of
names are
rejecting the
different
main
Lordship.
voter list Lordship. Yes, Lordship. If Lordship tribunal has no power at all, Lordship, that is the question is different Lordship. But he has the full power Lordship. And only this mark, the Lordship, whether actually you have Lordship shifted on Lordship, this if the tribunal record now Lordship, I can Lordship it is now right now Lordship. Only this much also. Yes, Lordship. Only simple Lordship and Lordship. These cases are Lordship, old cases Lordship. At that time also Lordship, the learned councils also Lordship. With the time Lordship, they were not fully aware Lordship. How much fact should be in the Douglas Lordship? They should not. They were not aware Lordship. Otherwise, they know it Lordship. But how to Lordship? That how much the date of birth, place of shifting Lordship? These are all are required or not Lordship? They are not aware Lordship. That's why they are not given Lordship. And Lordship. Then Lordship only to that point, Lordship, only the particular point, Lordship, if the case is demanded back, Lordship, kindly, then I can educe Lordship, 2-3 witness, even Lordship, more Lordship, only that point, Lordship. Because only this point, Lordship, that is the ground of rejecting my total list of 60 and 71, Lordship. And others, regarding other documents, says that these are the post document. So after rejecting the documents of 1960 and 70, these documents have no value, Lordship. This is the main ground of the other rejecting other documents. And even Lordship, the 71 documents also, Lordship, there is my father's name is there, Lordship. Even Lordship, the 66 goes, Lordship. Then also 71 is there, Lordship. Then also at least my name, I should be declared from the esteem of the 66 to 71, Lordship. But that is also not given, Lordship. So, Lordship, I can say, Lordship, that tribunal only, Lordship, he's wait for this, whether when I will commit a mistake, then he will take this point, Lordship. Otherwise, he can ask, Lordship.
And my lord, father's name becomes Kasem Ali instead of Abul Kasem Lordship in 1985 voter list Lordship. So many discrepancies are.
So, no,
There,
only
Lordship.
Kashmir Abul Kashim, this much, nothing else.
Kasem Ali and their places are also different Lordship.
Abul Kasem.
Yes.
How can Abul Kasem be same as Kasem Ali?
Lordship, father's name is same, Lordship. Abul Kashim and Kasem Ali's father's name is same. Lordship.
Kasem Ali alias Abul Kasem.
Yes, I have said, Lordship.
And in the voter list, is he recorded as
Abul Kasem.
Abul Kasem.
Yes, Lordship.
Kashem Ali, Abul Kashem, both are Lordship. In the only 71 Lordship, Abul Kashem, and thereafter also Kashem Ali, Lordship.
And mother's name also become different Lordship.
Mother's name is?
Daihapu Nessa
Huh.
becomes Siamon Nessa, Lordship.
Only Nessa is same, otherwise Baki is
No,
different.
Daihapu and Siamon Lordship.
Ah.
Name also different Lordship.
Mother Lordship, mothers, if father's Lordship established Lordship, then mother Lordship, I have 3 mothers Lordship, their son Lordship is becoming 3 mothers Lordship. Their son Lordship, that one Lordship.
If you say Koteshwar Singh and Koteshwar Das, then what will happen? Change everything. The name is same. So what? Das and Singh are different identities. You have to explain how he became a Das.
But I have taken the plea Lordship, the Kashem Ali, Abul Kashim, the same
We
person.
will
Lordship. I have
hear.
taken the plea Lordship.
We'll hear because this is your document also not very clear. You have to be clear. You have to clarify everything. That is why they are doubting. They are doubting because of that reason. You have to clarify. When they doubt you that you are a foreigner, then you have to be careful. Okay, list again. Criminal. Hearing criminal.
Yes, sir. Hearing list,
Obliged.
Criminal, anybody? Yes. Any amicus ready? E. Today, any kind of fix assay? 67. Okay. Oh, visita. Defendant, yes.
There is one item 33 and 34. In item 33, I am the amicus, my lord.
33.
33 and 34. It is
QT Mahan.
my lord.
Okay. QT Mahan, item number 33.
Yes.
One is by engaged counsel.
Uh-huh. The engaged counsel, Mr. PJ Soikia,
My lord,
B. Buragohai.
two criminal appeals, my lord, arising out of the same judgment for the single person. One sent from the jail, so jail appeal, and another by PJC, my lord. He had filed it. In fact, the one filed by the PJC is earlier.
Which
That-
PJ Soikia? Senior advocate, PJ Soikia?
I don't think.
Do you have any idea?
My lord, may peruse page 85 and 86 of the paper book, my lord. At page 85, the jail appeal was admitted on 17/11/2017.
No problem, no problem.
At page 86, the.
No problem, no problem. Well, the PP is there already. You're there, no? Then let him also file his documents, find this, otherwise. আছে কই extra copy আছে extra copy মানে কি why it is ইমান দাম একটু বোর্ড সাইড আছে নাকি আচ্ছা দি দিও লিখো হান মিস্টার বি প্রসাদ লানে amicus story. These two appeals, namely, these two appeals are preferred by the same person, one through the jail and through engaged counsel, Mr. PJ Saikia, who is not present today. First of, since the appeal is preferred against the same judgment, and since Mr. B. Prasad has been already appointed by this court as amicus curiae, to represent the interest of the appellant, of the convict appellant Srimati Hyoti Mahan, we have the view that we can proceed with the matter even if the earlier engaged counsel, Mr. PJ Saikia, is not present today. Next paragraph. By this appeal, in these the convict, namely so was
Page 56.
convicted as
Page 56,
page 56, huh?
paragraph 39,
Convicted for committing offense under section
302.
302 IPC of IPC and is sentenced to undergo rigorous imprisonment for life, and also was imposed a fine of ₹1,000, in default of which to undergo further sentence of 1 month, simple imprisonment 1 month. So next paragraph. The conviction and the aforesaid legal process resulting in the conviction the appellant was initiated after an FIR was lodged on
Page
Well,
5.
an FIR was lodged on 23/5/2014
23/5/2014
by one Dambaru Mohan Phukar, Gaunbura of the village, stating that at about 7:30 AM on that day, Srimati Hyoti Mohan, wife of Bhola Mohan, resident of Maudumoni village, under Sipon police outpost, hacked her brother-in-law, within bracket, husband's younger brother, Ghana Mohan, to death with a dao in her house. Full stop. Accordingly, a police case was registered, being what is the police case number?
SC 164.
One police case number SE.
Case 6. Left hand exhibit 1.
SE naki?
That is police outpost case number.
Yes,
Otherwise,
E.
it is PS case number 64 of 2014.
64 of 2014.
Moranhat PS case number.
More than PS case, huh? Consequently, a full investigation was carried out. A thorough investigation was carried by the IO. And upon completion of investigation, the applicant was committed for trial before the
Session judge.
Court of Session Judge
Sipsagar.
Sibsagar. And on committal, a charge sheet was framed. Charge was framed. Please, charge. Please.
Ma'am.
String of charge.
Page 77.
Page 77, charge.
Oh, sorry, charge, my lord. Sorry. Charge framing order is not there. Charge sheet is there.
According to the criminal charge was framed against the appellant, that on 23/5/2014 at about 7 AM, she had committed murder by causing the death of her brother-in-law or son-in-law?
Brother-in-law.
Should be son-in-law, no? Wrongly written, no?
Wrongly.
A son of Ghana Mohan, and thereby committed offence punishable under section 302 of the IPC. The appellant pleaded not guilty to the same. Accordingly, trial commenced. Next, in course of the trial, the prosecution examined as many as 11 witnesses.
My lord.
The defense did not adduce any evidence. And accordingly, her statement was recorded under section 313 of the CRPC. Next paragraph, the learned trial court, on appreciation of the evidence on record, held that the charge against the appellant has been proved beyond reasonable doubt, and accordingly convicted her under section 302 IPC and sentenced her to undergo RI for 1 year as mentioned above, for life as mentioned above. Before we proceed to examine the contentions advanced in challenging this conviction, we'll first briefly refer to the evidence which has been brought on record. The first witness who was examined by the prosecution was Dambru Mohan Phukon, the Gaunbura and the informant, who stated that who narrated about incident as mentioned in the FIR, and also stated that when he was on the day, when he was returning home after tethering cattle and collecting crops, the accused having a down in hand, arrived and told him that she had come after killing a person. And when he asked as to who she had killed, she replied that she had hacked Ghana to death. And on being asked the reason, she replied that Ghana used to quarrel with her. Thereafter, the PW1 called Dinonath Phukon, who was working nearby, and told him that the accused had reported about the said crime, come and reported about the said crime. Then, thereafter, Dinonath Phukon went to the house of the Ghana Mohan, the deceased. He also stated that the house of the appellant located near the deceased house. There, he called some persons and went to the house of the accused appellant along with them, where they found Ghana Mohan lying injured in the backyard of the appellant with bleeding on his head, with his head bleeding. He was alive at that time. Then he made a phone call to the Sepon police outpost, and police asked him whether police told that if the injured was still alive, he may be taken to the hospital. Thereafter, the ambulance was called, but on arrival of the ambulance, the injured person died. Thereafter, he lodged a fire as a Gaumbura, which was proved by him. In a cross-examination, he admitted that he did not see the incident, but he stated that the deceased Ghana Mohan used to quarrel and cause ruckus under the influence of liquor, though the behavior of the accused also appeared to be abnormal. Stop. Next para. The next witness examined was Dr. Deepak Gogoi, is PW2, who conducted a post-mortem examination on the dead body of the deceased. And he found the following injuries, which he stated before the court. External appearance, incise injuries, cranium, spinal, thorax, some, according to he also gave his opinion that the death was caused due to shock and hemorrhage as a result of injuries sustained over the body. And he also stated that the injuries were sufficient to cause death of the deceased in normal course of nature. Though he was in the cross-examination, he was asked as whether such type of injuries, in the cross-examination, he was asked whether such a type, in the cross-examination, he also stated such type of injuries may be caused by falling on sharp cutting object. Stop. Next para. The next witness examined was Dambaru Nath Phukon, PW3, who stated that the incident, on the day of incident, while he was raising fence near the house of Dambaru Mohan, Gaumbura, within bracket the complainant, the said Gaumbura called him called him, and going to this house, he saw the complainant and the
The name
appellant.
should be Dinanath Phukon.
Dinanath, huh? Dambaru Nath or Dinanath?
Dambaru is number 1, PW1.
PW3, no, my name is Dambaru Nath.
Signature on the next page.
Okay, typing mistake. Copy. Okay. Then Dinonath, huh? Not Dambaru Nath, huh? Dinonath, huh? On being called by the complainant, he went there and saw the appellant and the complainant with he saw the complaint and the appellant with a dao in her hand. Whereupon he was told by PW1 that the appellant had come to his house informing that she had hacked her brother-in-law Ghana Mohan. He also, the PW3 also stated on when asked, the appellant stated that being helpless, she hacked Ghana Mohan and also showed him the dao by which dao was stopped. Thereafter, he along with the Gaumbura went to the appellant's house, and on reaching the appellant's house, they found the Ghana Mohan lying dead on the Eaves Street. Mane? What is Eaves Street? Eaves Street mane ki? To where's the original file? Original file. Eaves Street mane ki? Brother, I've had.
The dictionary meaning is that it is the width of the ground around the house or building which receives the rainwater dropping from the eaves.
And thereafter the Gaumbura informed the villagers and the police, later on the police came. In the cross-examination, PW3 also stated that the deceased Ghana Mohan used to cause ruckus under the influence of liquor. Though he also stated that he did not witness the incident. The next witness examined was Tutumoni Mohan, Srimati Tutumoni Mohan.
She is the wife of the victim.
The wife of the victim. She stated that in the previous night of the incident, the deceased had gone to enjoy Bihu Mela. And he was seen dancing in the Bihu Mela till morning. She also went for Bihu and went to bed at around 9:30 AM next day. Gopal Mohan, the complainant, came and awakened her, and she found her husband lying dead with bleeding cut injuries in the house of the accused. He was informed by the Gaumbura that the appellant had committed the said offense. But she did not ask the appellant anything about it. She also saw cut injuries on the hand of the appellant, eyes and head. In a cross-examination, she stated that, what is it? Accused Hioti Mohan, okay, that the appellant Hioti Mohan suffered from mental illness and she used to babble a lot. However, she denied in the cross-examination that some other person had hacked her husband and that she had adduced false evidence. Next paragraph. The next witness examined was Bornali Mohan, who is the sister-in-law of the appellant. Daughter-in-law of the accused, appellant. She stated on hearing that her father-in-law had died after being hacked by
It should be sister-in-law.
sister-in-law.
Sister-in.
Yeah, okay. No. This Bornali is a sister-in-law.
Sister.
The sister-in-law, who said that on the day when she was informed that the appellant hacked the appellant had hacked Ghana, she went to the house of the appellant and saw the deceased lying on the courtyard of the house of the appellant. And she showed the appellant sitting on the veranda itself. Next, huh? Daughter-in-law. Daughter-in-law, no.
This is, Ghana is
Accusing my
Because-
mother-in-law, so she's a daughter-in-law, not sister-in-law. Huh?
sister-in-law.
Daughter-in-law of the accused.
Daughter-in-law of the accused,
She
not
said-
sister-in-law.
he said
But the victim is the brother-in-law.
No. She said this is Ghana Mohan, the brother-in-law.
In
of the
essence.
accused.
This is Ghana Mohan was the brother-in-law of the accused.
She rightly said. I learned and learned.
Of the accused. Correct.
Yes, she
I
said-
stand corrected.
Yes.
Then, the next witness was Bhuvan Mohan, PW6.
He is declared hostile to style, which is the Caesar accused matter.
Who stated he learned from the others that the appellant had hacked Ghana Mohan. And he stated he did not see the dead body. Though he was a witness to the seizure memo in respect of the Dow. He was of the Dow. He was a sin. He was, however, declared hostile by the court at the instance of the prosecution. And he denied that having stated to the police that the appellant had confessed to the said crime. She also stated she was not eyewitness and did not see the police seizing the Dow from the possession of the appellant. PW7, next witness examined was Shri Girin Borgohain. The brother-in-law of the deceased. He was an eyewitness, but he came on hearing about the incident. He came to the house of the deceased where he found of the appellant, where he found the deceased lying. And he was witness to the seizure of the Dow. The next witness examined was PW8, Bibha Mohan, Mrs. Srimati Bibha Mohan. She was not witness, she was an eyewitness. But she was a witness, but came to the house of the deceased. PW9, next witness examined was Bhola Mohan.
husband of the accused.
Husband of the accused, huh? Husband of the accused, who was not eyewitness, nor did he know he said he did not know how the deceased was killed. The deceased was his own brother was killed. The next witness examined was Pradeep Mohan, PW10, the son of the appellant. Who stated that when he returned home after participating in the Bihu Mila, he found a dead body of Ghana Mohan lying at the back of their house. He was then declared hostile, and he also denied having informed the police about the injured body of his uncle lying on their backyard in a pool of blood. And that pool of blood. The next witness examined was PW11. The IO of the case. On completion of adducing of evidence, recording of evidence of the prosecution witnesses, the appellant accused was examined under section 313 CRPC by the court. As regards the various incriminating materials which are brought on record, and on being confronted with the same, the appellant denied having any knowledge and was stated these are all false. And her stand was that she had been falsely implicated. The learned trial court, however, considering the evidence brought on record, was of the view that the prosecution had been able to prove the charge against the appellant beyond reasonable doubt and convicted accordingly under section 302 IPC and the sentence him to life imprisonment as mentioned above. The learned trial court, in coming to such conclusion, learned trial court relied on the extrajudicial confession made by the appellant before the Gaumbura PW1 as well as which was PW1.
Only PW1.
PW1, which was corroborated, which the court felt court found, which the court held it was corroborated by PW3. The learned trial court held that the evidence of PW1, PW3 fully established the confession made by the appellant that she had finished Ghana And on being asked the reason, she also stated that they were informed that, the appellant also informed them that the deceased used to make quarrel with her, and accordingly finished him. The trial court noted that the presence of since the PW1, the house of PW1 was located about a distance of 400 to 5 away from the place of occurrence, and his presence is a Gaumbura in the village cannot be doubted. It was also the trial court also of the view that the evidence of PW3 fully corroborates the evidence of PW1, who was also staying near the house of the PW1, and the PW3 was staying near the house PW1. Then the trial court also noted that the evidence of PW1 and 3 were not shaken at all by the defense during the cross-examination. In fact, nothing was elicited from the evidence of PW and PW3 to the advantage of defense. Apart from general denial, the trial court held that the confession made by the appellant was clear. There was no vagueness, and it also had been proved that after the said confession, they had all gone together to the house of the appellant where the deceased was found lying at a bedside. The trial court also observed that there is nothing to show that the extrajudicial confession made by the deceased was under inducement or threat. Thus, it was voluntary in nature. The trial court also noted that the seizure of the dog from the appellant has been also proved by the evidence of the IO as well as the PW7. The trial court also noted that during her examination under section 313 CRPC, she merely denied having any knowledge, but did not offer an explanation on the circumstances which were brought to her notice regarding extrajudicial confession and also about the seizure of the weapon. The learned trial court also consider the aspect as to whether the appellant committed the offense with intention and knowledge. Though it has been brought on, it has been brought through the evidence that the appellant appeared to be unstable, yet the appellant never took any specific plea about the mental status of the of her mental status to make any claim that she was not in a position to understand the act committed by her, alleged. The court noted that while making confession by the appellant before the extrajudicial confession, while making the extrajudicial confession by the appellant before the PW and PW3, it was done in a very natural manner. Referring to the injuries received by the deceased, which is reflected in the post-mortem report, the learned trial court took the view that these injuries were were inflicted by the appellant with full knowledge and intention to cause the death of Ghana Mohan, and that there is nothing on record to show that she did so either under mental imbalance or by way of by exercising the right to private defense due to any quarrel with the deceased. In fact, no plea of right of private defense was taken by the appellant. But according to the learned trial court held that prosecution has been able to prove the case against the appellant beyond reasonable doubt. Yes, Mr. Prashad, what do you want to say?
First point is that there was no eyewitness in this case.
Yes.
None of the witnesses have said that they have witnessed the occurrence. Some of the family members were there in the house at the time when the incident occurred, around 7 in the morning. Her sister-in-law was in the house. She was sleeping. Leaving her sister-in-law who was within the vicinity, she went to PW1. The accused, the appellant, knew that her sister-in-law was in the house. She was sleeping.
Her sister-in-law means the wife of the deceased.
Mother.
Huh?
Mother. Says PW4. PW4 was in the house.
Yes.
Not informing her, the appellant goes to PW1, who resides some distance away from the place of occurrence. Second point is that this is a case of an extrajudicial confession matter. The prosecution has to prove their case. Extrajudicial confession is a very weak piece of evidence.
Yes.
Basing the conviction only on the extrajudicial confession is it's without any proof, if I may say, because the prosecution has to prove their case on their own standing. Now they said that they had seized the dhow on being shown as stated by PW1. However,
Hmm.
the others have said that the dhow was there in the place of occurrence. It was not handed over by the appellant.
Hmm.
The lordship may see the seizure list for a moment. At page 59, madam.
Yes,
Description of the seizure down below. One Mechi dhow with a wooden handle. The dhow along with its handle is about 2 feet long and a little blood stain is found in the dhow.
Hmm.
And the witnesses were PW1, PW6 and PW7 to the seizure memo.
witness, sir, PW6,
PW1, PW6 and PW7 are the seizure witnesses.
6 is the,
Bhavan Mohan,
he's what? 21.
he's declared.
No, correct, he's the related, how
Not
related?
very related,
And not related,
not
6 not related,
related.
7. The deceased was my Bindyo. So, Boro Gohai,
Victim's wife, brother.
Huh?
Sorry,
victim's
Hindu.
wife's brother. That means accused, the brother of the accused, okay?
No.
And then
Victim's wife.
PW7,
Victim's wife.
oh, victim's wife's brother, okay, victim's wife's brother.
You will also
Brother-in-law
peruse their statements for a moment once again, madam.
of the victim. Brother-in-law of the victim. On a kill Ghana, I was from a
Page
person.
21, my lord. That is PW6. I'll place the cross, my lord.
Yes.
Page 22. I did not witness the incident myself. I did not see police seizing the dhow from the possession of the accused. So he says that the dhow was not seized from the possession of the accused. He further says that the police obtained my signature in a blank sheet of paper. The seizure list was not prepared when the signature was obtained.
This is Ghana Mohan was the brother-in-law of accused Hevati Mohan.
Bhavan Mohan is,
No, but then who is this Bhavan Mohan?
he may be a neighbor.
I came to learn from the accused act, so not related.
Not
PW6 is not related, no?
Not related.
Perhaps a neighbor, no? Mohan going to the house, going to the house of the accused, I saw police in his courier. I did not see the dead body. The police questioned me. Police seized the dhow through Exhibit 2. Police seized the dhow.
That
Who is
he is denying all this statement. It is not a fact that while making statement before the police, I stated that so and so. He has denied everything. He
Given
has
the
been
fact of
declared
making
hostile.
some, I stated that when police person from confessed to hack Ghana with the Beauty is the wife of Bhola Nath. Ghana Mohan used to live separately. It is not a fact I have reduced false evidence. It is, I do not witness, I do not see police in doubt from police. Then PW7,
PW7, my lord.
I know the accused. I knew deceased. The deceased was my Bindyo, sister's husband. So
At page
Girin
24,
is the brother-in-law
brother-in-law
of the deceased
victims of the deceased.
and Dior of the accused. And accused also, he also related to accused.
Certainly,
Because deceased and the accused are related.
they're
So accused,
Accused is the sixth trained
appellant accused is the
sister-in-law of the victim,
Sister
brother's
in law
wife,
of
This is.
the victim. It is the
brother's wife.
victim younger brother, sorry, I don't.
The
Younger.
Wife of the victim's younger brother. I heard on the accused had killed Ghanamon. I was at home that day. Then a person in the house informed my father Ghanamon had fallen ill. Then
second
my
paragraph.
father was that by my father day, when she had been in the hospital. I found Ghanamon with injury near his ear, lying dead in the house of the accused. That the see in the house of the accused. That is proof. Huh?
The dead body was found in the
Ah,
house. of
dead
the
body in the house of the accused.
Not in the accused, because
Ah, but then
they
said-
reside together, my lord. They
I
reside together
found
in the same
Ghanamon with
premises.
injury near his ear, lying dead in the house of the accused. I heard that the accused had hacked Ghanamon. Now, it is. See, the fact remains that that the dead body of the deceased was found in the house of the accused is not.
Not
It-
the house. It
Why
should
not?
be-
But
it is in the
PW one
same
says
premises.
also.
They are in the same, they reside in the same premises.
I was at home, then PW, no, there was one that, what is that? That we were looking at a dictionary. Is there, the drip, P2?
Drip.
What is it? Who has said that?
Three.
PW? See, I found the dead body of Ghanamon lying at the back of our house. Who is this? Bhola Mohan. Who is Bhola Mohan? Accused is my mother. See, page 29.
Husband's daughter.
Huh? The accused is my mother.
Right.
That means Bhola, Pradeep Mohan is the son of the accused. Huh?
Bhola is husband of.
Bhola is husband.
No.
PW9.
No, 29. Page 29. Pradeep Mohan.
Pradeep Mohan is my son.
Accused is my mother.
He is son of the accused.
Therefore, Pradeep Mohan,
In the third
it's a-
line, it says, we
Son of-
share the same courtyard.
he used to, Ghanamon was my paternal uncle. Ghanamon died about 1 year ago. He used to live in a separate house.
Separate house, but the same courtyard.
Correct,
That-
same courtyard. But we shared the same courtyard. One day, about 1 year ago, after enjoying Bihu Mila, I returned home the following morning, where I found a dead body of Ghanamon lying at the back
of
of
our
our house.
Yeah.
Back of our house, their house, not in the courtyard. It was the back side.
Backside,
Courtyard is in the front.
yes.
Backside, he also admits, I know this much. He was declared hostile. Obviously, how can he implicate his own mother? But he admits that the dead body was in the backyard, backs. How come? See, there is one then anyway, then what is your other case? What is
Other
your,
point, my lord,
then?
the lordship had seen in the scissor list that there was some blood stain in the,
Yes, but
Murder
in the Dao.
but the murder weapon was not sent for the forensic to test whether the blood was human blood or any other thing. Or the fingerprints in that dao was of the applicant.
Okay.
It was not done.
Bihu Mela, so Bihu maybe cutting some khana naki. In Bihu, what kind of Bihu Mela? This is a time?
After,
Huh? No,
Yes,
what
not
is the date?
exactly that.
Date?
April,
April.
April.
April mane ki Bihu?
Yeah, but it was in May.
Rongali Bihu.
Rongali.
In
this is
Rongali Bihu, of course, people enjoy
Dance.
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 Primary is dance, eating is there always.
His wife said that he was dancing.
He was dancing all night.
But this was post Bihu in the month of May.
No.
Bohagi Bidai.
No, but 1 year after enjoying Bihu Mela, he was
But there
dancing.
was a Mela, there was some function,
23/5.
Huh? Sorry?
23/5.
May,
26.
Bohagi Bidai,
The
By
Boha-
that time-
ki Boha-
Bohagi Bidai.
Boha Bidai. Then
Say
you
bye
eat.
bye to Rongali Bihu.
Wrong, then you eat. No, there is a consumption, no? So yes, what is your case? Tell us, Mr.
That is,
Prashant. Yes,
it was not sent for forensic.
Yes, yes.
Fingerprint, no blood. stain. No blood stains.
oh.
We reached the backyard, we were lying,
Hmm.
still bleeding but not.
Hmm. So this blood stain Dow. The blood was not sent for,
Forensic
forensic.
to detect whether it was a human blood or the fingerprints in that was of the appellant.
With the human blood. Or the fingerprints of the appellant. Yes,
Lordship had seen the postmortem report.
yes.
There were so many injuries,
Hmm.
not a drop in her clothes of the appellant. Her clothes were not seized. No blood stain in her body or in her clothes.
Let us come that page number or that,
His evidence is at page 13.
incise injury on 2 centimeter nose,
Nose,
chin, ear, scalp, occipital bone, left parietal eminence, side, incise on the skull, fracture of frontal bone, membrane healthy, sensor
and most of the injuries are on the face, my lord.
on the face.
One injury on the chest,
Hmm.
rest all on the face. No blood stains were detected on the body or in the clothes of the appellant. Are the
Yes,
the prosecution has not proved any motive, my lord. Why the appellant would kill the victim? That it-
he
No,
was dancing and quarreling with her.
but that cannot be.
Maybe she didn't want him to dance near
Whenever he
him.
consumes liquor.
He
has
was
to cause a
continuing
fuss.
dancing Bihu dance near her. Maybe she got irritated and just killed her. Huh? No.
PW says that,
Huh?
PW3
PW3. Let us see PW3.
in C,
PW 1 and 3 said the victim used to quarrel and cause ruckus.
Ah,
page 16.
page 16. No? PW3.
Finding as
PW3.
PW 3 says
next page 16, finding is.
He's a neighbor. Accused my neighbor.
Hmm.
I knew this is Ghana Mohan. This is Ghana used to cause ruckus Satyajhan.
Before
Oh.
the receipt, the accused replied to
They-
being helpless, he had Khanam.
I don't witness. He would consume liquor and cause ruckus.
Right.
They also admits in the cross.
PW 1 and PW 3.
Huh?
both.
He also mentioned one also.
One also, my lord.
Ruckus. Yes, then motive has not been established. Yes, then next. What is the other point?
And the
Ground.
last one is, my lord, PW 1 and PW 4 has said that I was suffering from some mental illness.
Suffering from mental illness.
Although I have denied all the charges, PW 3 says that I have admitted before them that being helpless, she had Ghana Mohan,
Hmm.
being helpless.
Being helpless.
So there,
PW.
PW 3, my lord,
Hmm.
page 16, third line. I have this much to submit.
That's all.
Right.
Yes, Lanet PP. What about the seizure? Can you say anything about the seizure? They say that seizure has not been proved.
Seizure has been proved without duly
Proved.
proved.
Duly proved.
Yes, blood has not been sent for a vessel, whether it is human blood or not, that is not done.
So
That blood.
how fatal is it?
Well, I do not think this, when other evidences are, there, I do not think it is fatal to the prosecution story.
Hmm.
Because so far extrajudicial confession made by the accused before the PW1, who is a village headman. Well, so far extrajudicial confession is concerned,
Yes.
what is looked into is before whom extrajudicial confession is made. That person's credibility is necessary to be looked into. He is a Gao Budha, and his house is situated at a distance of about 400-500 meters from the house of accused. She went there, informed him, but I do not find anything to disbelieve him regarding extrajudicial confession. And this extrajudicial confession is further corroborated by other evidences. The evidence of PW son, PW, though he is declared, it is no, it is a known law that though an witness is declared hostile, his entire evidence has to be thrown into dustbin. PW 10, your lordship may kindly come to page 29. He has been cross-examined by a prosecution.
Judicial confession is corroborated by PW son, na? What?
Son.
According to you?
This is one,
PW?
Dinonat. PW3 also says.
PW3.
Yes.
Dinonad, na?
Dinonat.
Who is Dinonad?
Dinonat, he was immediately called by this PW1 after.
Okay, yes, PW3. Yes, yes.
And PW9.
PW9 also?
And
Yes.
PW9,
PW9. Cross.
PW9 says he is a sister, he is husband of accused. PW9 does not say, I think.
Then?
No. Cross examination, page 28.
It is not a fact. I told you, I went to one funny, have a walkman, I said, I have hacked Ghana.
Denied.
Denied.
PW9, my lord.
Hmm. Then who is the other one corroborating? PW3 and 9, and somebody else also said, no, there was a cross-examination, he denied having.
Then my lord, PW10, during cross-examination.
PW?
inquiring about PW10. Son.
Page.
Page, the relevant page is at page 30. This is cross-examination by prosecution.
I
Please.
told before there's some account, I saw police, I saw my uncle lying down and when I learned in my head.
Inquiring about the incident, I learned that my mother had hacked my uncle to death.
So PW9 is the husband. na?
PW9 is the husband, 10 is
And
the son
PW10 is the son.
of the accused. And the recovery
I
of
found a
dead body,
dead body.
and recovery of the dead body, that is
From
also
the
a
house.
uh,
Yes,
uh,
not explained.
link to the same
Recovery.
in the backyard of the this. So all this indicates unerringly that the crime was perpetrated by the appellant.
What about the motive? Mens rea.
Motive, my lord, these things, my lord, intention, these are state of mind. It is difficult to find direct evidence regarding
If there
motive.
is no motive,
Well,
then
from the cross-examination of
if the motive could not be established, then can you still convict under 302?
well, that has to be inferred from the motive, intention, all these are state of mind.
Because his wife says that he was dancing to the violin. He went to sleep.
Anything else? That's all?
No, regarding motive, my lord,
Motive.
I submit, my lord. This state of mind, it is difficult to find, my lord, direct evidence. That has to be inferred from the evidence on record, my lord.
Okay.
She immediately after committing the offense, she went to my lord, PW1. Told him that I have helped him because he was quarreling, and in cross-examination also defense has brought it on record that my lord, he used to die. This is used to quarrel with my lord, under the influence of liquor. So my lord, with a view to getting rid of these things, my lord, she had committed the crime. Now, whether it will be 302 or 304, my lord, I leave to your lordship.
If I may add, my lord, it has
Yes.
been proved that the victim was of quarrelsome nature, my lord. Nothing has been stated about the appellant as such, that she was of such nature that she could have killed somebody.
Nico Hart. Mr. Sushant, Planet Council and myself preparing for the appeal has submitted it. It cannot be said that the prosecution has been able to prove the charge against appellant beyond reasonable doubt for the following reasons. Number one, firstly, it has been submitted there was no eyewitness. In absence of an eyewitness, a charge to be proved beyond reasonable doubt, the other circumstantial evidence has to be clearly proved. In the present case, the only circumstance and also the extrajudicial confession which the appellant was alleged to have made have to be properly established, which has not been done. It has been stated that it has been submitted that there were already members of the family of the deceased as well as appellant in the house when the incident allegedly occurred. But according to the prosecution, instead of reporting the incident by the appellant to any of the near ones staying in the house, the appellant apparently went away to the house of the PW1, which is also located far away at around about 500 meters away. The other witness, PW1, I found her. The other witness who also allegedly corroborated the evidence of the appellant confessing to the PW1 was also staying near the PW1 and far away from PW of the appellant's house. Thus, this creates a doubt as to whether the appellant really went out to confess the crime allegedly committed by her to a person who is staying away from her house and not informing the other immediate relatives in the house, in her house and or the house of the deceased. It has been submitted that as it is now well settled that extrajudicial confession is a very weak piece of evidence and it cannot be the sole basis for conviction of a person unless there are other corroborative evidence which are absent in the present case. In fact, it has been submitted that the seizure of the weapon of crime, that is a dao, which was allegedly used by the appellant, was also not been proved. The witnesses had resiled from the statement stating that the dhow was seized. Referring to PW. Who is that? PW?
Seven has said that.
Seven.
he signed in
Seven.
blank paper. Seven.
7. Referring to
Page 23.
this one, specifically referring to the evidence of PW7, page,
23.
huh?
Well,
PW7 is page
23.
23.
Well, it is PW six, man. PW six.
No, PW come, PW,
Six.
coming to the evidence of PW6 was one of the witnesses to the seizure memo of the dhow, seizure memo in respect of the weapon of dhow. They said PW 6 stated that he did not see the police seizing the dhow from the possession of the accused. And the police obtained his signature in a blank sheet of paper. Accordingly, it has been submitted. Further, PW7, who is another seizure witness, also stated that
Page 24, second paragraph. On being shown by the accused, police
said
seized
that also stated, deposed before the trial court, during the trial, on being shown the weapon of crime, though he admitted to the signature, he stated that he has not been able to recognize whether the said exhibit was the same seized dhow or not. Thus, it has been submitted that since then, thus it cannot be said that the seizure of dhow has been properly proved. Under the circumstances, if the prosecution has not been able to prove the seizure of the crime weapon, it certainly can create a doubt on the actual occurrence also. Next, it has been also submitted that it is on record. Where is that blood?
Caesar memo, man.
Yes. Page
59.
Page 59. It also record that. It also is on record that in the seizure list, seizure memo, it has been mentioned that there was a little blood stain found on the dhow. However, the said dhow was never sent for forensic examination as to ascertain as to the nature of the blood stain which was found on the dhow and also the fingerprints. Therefore, it can be said that this blood stain was caused due to the assault on the deceased, allegedly by the appellant, and that she had actually used the dhow in as much as if the forensic examination had been conducted. In absence of forensic examination, it cannot be conclusively established that the appellant had used the dhow or that the blood was that of the deceased. Hence, there is certainly a reasonable doubt has been created on account of non-examination of the weapon of crime, but because of non-examination through forensic tests. It has been next where Mr. Prasad further submits that the post-mortem report clearly indicates a number of injuries caused on the found on the dead body of the deceased. And the doctor also had opined that the death was caused to the injuries due to hemorrhage, shock and hemorrhage due to the injuries received by the deceased. However, the prosecution has not been able to show any blood stain on the body of the appellant or on the apparel used by the appellant, which certainly would have been found if the deceased had received several injuries, that too on the upper part of the body, upper part and the face of the body. Thus, the absence of any record to show blood stain on the body or clothing of the appellant creates another doubt as to whether the appellant was the real assailant. It has been also submitted by Mr. Prashad that the prosecution has not been able to establish the motive behind the alleged crime. No evidence have been brought on record to show any previous enmity or any circumstance which would lead to the appellant assaulting the deceased by Dow. In fact, the evidence of PW1, PW4 would suggest, PW1 and PW3, no?
PW1 and 3.
3 would suggest that the appellant was suffering from certain mental
illness is PW1 and 4.
1 and 4, mental illness. Therefore, if the appellant was suffering from mental illness or imbalance, in absence of any clear motive imputed to her for committing the offense, a very important ingredient of Section 302 is missing, in which event certainly no case can be, certainly it can be said that the charge under Section 302 can be said to have been established. Anything else you want? That's all. In response, Mr. Das, Lanet,
Motive.
motive have mentioned this. In response, Mr. Das, Lanet, additional PP has submitted that the submissions of the appellant are without any substance. Even if there is no eyewitness, the extrajudicial confession made by the appellant is highly credible. Though Judas extrajudicial confession may be considered to be a weak piece of evidence, in the present case, there cannot be any doubt about the genuineness of the extrajudicial confession, as the said confession was made to a responsible person in the village, that is a Gaumbura, PW1, Gaumbura, PW1. No motive can be imputed to the Gaumbura for making any false evidence, to make any false evidence before the court. He is a responsible person. PW1 is a responsible person, and it is quite natural that he would testify actually as to what actually transpired in the transpired on that day. And as such, in absence of any, and as such, since the extrajudicial confession was made to a responsible person like a Gaumbura, voluntarily, that too voluntarily, no doubt can be raised about the extrajudicial confession And I said, even though it may be a weak piece of evidence, nevertheless, it can be based for sustaining the conviction. Further, it has been submitted that the said extrajudicial confession stands fully corroborated by the evidence of PW3, who also is not an interested witness and who happened to be working near the PW1 at a time of reporting of the at a time of making the extrajudicial confession by the appellant. Next page. It has been also submitted by learned PP that the said extrajudicial confession is clearly also corroborated by other evidence on record. That is that the seizure of the dog
Recovery of the dead,
by the
recovery of the dead body.
recovery of a dead body from the
Yeah,
house of the appellant and recovery them, and as such, that the circumstances can be said to be conclusively proved. These circumstances, read along with the extrajudicial confession, can certainly form a complete chain of circumstances which conclusively establish the guilt of the appellant. It has been also submitted that as far as the motive is concerned, though it is difficult to get any direct evidence as to what transpires in the mind of an assailant, yet from the circumstances it can be clearly deduced that the appellant knew very well that by inflicting such injuries on the body at a vital parts of the body, it would cause death in normal circumstances, and as such, it will be sufficient to establish the mens rea on the part of the assailant. As regards the non-examination of the of the dove as well as the blood stain on the dove, on which much emphasis has been laid by the learned amicus, it has been submitted that the failure to do so will not be fatal, inasmuch as the other evidences fully corroborate the use of dove by the appellant. And from the nature of the injuries received by the deceased. Anything else? That's all. We have heard the learned counsel for the parties as well as gone to the we have heard the learned counsel has prepared the material record and also examined the blue and also given our anxious consideration on the finding conclusion arrived by the learned trial court in convicting the appellant. As mentioned above, there is no eyewitness to the incident. However, absence of eyewitness may not be fatal inasmuch as the facts and evidences which was unfolded before a trial court all appeared to be more or less contemporaneous in nature. the reporting of the making of the state, making of the extrajudicial confession on which the learned trial court has based a conviction was done almost soon after the incident had occurred. We have also examined the conduct of the witnesses, which makes us feel that the extrajudicial confession was indeed made by the appellant. Though the appellant did not immediately report to his near and dear ones who were present in the house, reporting to the Gaumbura does not appear to be unusual. In fact, rather reporting a serious incident, a criminal incident, to the Gaumbura, who is the headman of the village, rather appears to be a natural course of action. We also have noted that the Gaumbura, there is nothing on record to suggest there is nothing on record to suggest any motive on the part of Gaumbura to falsely implicate the appellant. When we read the evidence of Gaumbura, he appears to be engaged in a normal day-to-day routine activity in the morning when the appellant appeared before him, confessing the crime with the dao in her hand. And the natural action of the Gaumbura was to ask as to why she had killed the deceased. Whereupon, after knowing the reason as disclosed by the appellant, saying that what is that reason? PW1? Huh? That the deceased used to quarrel with her. The Gaumbura immediately told his neighbor, Dinonath Phukan, who was working nearby, and also informing of what the appellant had confessed to him. The said Dinonath Phukan also testified before the court as DW3 and fully corroborated what had been narrated by PW1. There is also nothing to suggest that the said Dinonath Phukan had any enmity or strained relationship with the appellant as to falsely implicate her. Therefore, the naturalness in which the reporting was made to them, and the naturalness by which the PW1 reacted and informed the PW3 appears that the appellant had indeed made the extrajudicial confession before the PW1. And we also noted that soon after the said appellant made the extrajudicial confession, both PW1 and PW3 went to the house of the appellant, where they found the deceased lying on the backyard of the house of the appellant, which is also corroborated, which can be seen from the sketch map prepared by the investigating officer in course of the trial, which was exhibited as Exhibit 5. Though the sketch map indicates that the house of the deceased was also located nearby, the dead body was found on the backyard of the house of the appellant. In our opinion, the presence of the dead body of the deceased in the backyard of the house of the appellant is of critical importance. That an incident happened in the dead house of the house was duly reported by the appellant by making the extrajudicial confession. Though other inmates of the house of the appellant did not report so, in our view, if the dead body was found on their house, they had the obligation to disclose as to how the incident happened, which we find to be missing. In this regard, we may also note that it appears that it appears from the cross-examination of the husband of the deceased, husband of the accused, as well as the son of the husband and son of the accused, that they were very much in the house. But they denied, during the cross-examination, they denied having informed the police that the appellant had hacked him. Though the evidence in the cross-examination in the form of denial cannot be a substantive evidence, yet it indicates the circumstances in which it throws a light. Though cannot be formed as substantive evidence, yet substantive evidence, yet the possibility of the said witnesses, the husband and the son of the appellant, trying to save their own mother and son, a mother and wife, does not appear to be unreasonable.
She herself showed the book.
That the fact that the dead body of the deceased was lying in the courtyard of the deceased, of the appellant, has been fully established by the evidence, not only by the evidence of PW5, who is the daughter-in-law of the appellant, as well as I found them. And as well as PW7. PW7, a seizure witness who stated that on being informed by his father that Ghano Mohan had fallen ill and had been taken to hospital, he went to the house of the accused, of the appellant, and found the deceased with injury near his ear, lying dead in the house of the appellant. So, these witnesses, therefore, these witnesses certainly, since the fact that the dead body of the deceased was found on the backyard of the appellant, having been firmly established, certainly it was incumbent upon the inmates of the house to have explained as to the circumstances leading to the lying of the dead body in their courtyard, which has not been satisfactorily explained by any of the inmates, but explained by the appellant in her extrajudicial confession. Therefore, we do not see any reason not to believe the extrajudicial confession made by the appellant. There is another issue which we like to, there is another issue raised by the appellant, that the dhow which was allegedly used, that the recovery of the dhow has not been fully proved. Though one of the seizure witnesses, namely PW7, had denied number 6.
PW7 has corroborated.
Ah, yes, PWC, though PW6
PW6.
had had resigned from his earlier statement that that he was a seizure witness by stating that that he did not see the police seizing the dog from the position of the accused, and the police had obtained signature in a blank sheet of paper. Yet the another seizure witness, PW7
He fully corroborates.
Huh?
He fully corroborates.
Huh?
He fully corroborates.
does not deny the seizure, though he could not remember during the in course of the trial whether the exhibit, the dog which was produced was the same dog which was seized.
Material exhibit 2.
Material exhibit 2 was the same dog which was seized. Full stop. PW1, however, remained consistent. PW1, who is another witness, eyewitness, huh?
With the seizure.
To the seizure, however, remained consistent, and no.
But so far PW6, he is declared hostile.
This
That
is-
is why we do not, perhaps we do not must give weightage to the his evidence regarding seizure.
Yes.
He's a
No,
hostile witness.
even if he has said so.
Yeah, that is
even if it-
all right.
So the evidence of PW1 clearly established the seizure of the dog. Therefore, even though one of the witnesses had resigned and did not support the prosecution witness, the other two seizure witnesses duly supported the seizure of the fact of seizure of the dog from the accused, from the appellant. And as such, in our view, of course, of that, and moreover, the said PW6 was declared hostile. And as such, and however, merely because a witness was declared hostile does not render the evidence, other evidence which is otherwise corroborated, to be doubtful. So as regards the non-sending of the weapon of crime for forensic examination as well as the blood test, in our view, though it would have been, though if such a forensic test had been conducted, it could have bolstered the case of the prosecution. Yet, non-examination, in our view, cannot be said to be fatal in the light of the surrounding circumstances which have been proved. It is proved through the medical record, proved by the medical records through the post-mortem report that the deceased had suffered sharp injuries which led to hemorrhage and shock, leading to his death. And the fact that the dead body was found in the house of the appellant would clearly link, will be indicated to the role of the appellant, which have been established by other evidences as mentioned above. Coming to the motive, which has been urged, which have been also highlighted by coming to the lack of motive, which have been highlighted by the Mr. Prashad, learned amicus curiae, we find that this issue perhaps, we find that this issue perhaps, we have, coming to lack of, we have given our interest consideration on this issue. As far as the knowledge that the sharp causing such sharp injuries with a sharp weapon would lead to death on the vital parts of the body, would lead to the death. we are the view that as far as the knowledge is concerned, it appears that no, this likhiye. No. As far as the motive is concerned, as the lack of motive is concerned, we are also the view that the prosecution perhaps has not been able to prove beyond reasonable doubt as to the mens rea and motive for causing such an injury by the appellant. In the evidence of PW1, which is the PW1 and PW3, which are the fulcrum of the prosecution witness, that is the extrajudicial confession made by the petitioner. On being asked, we observe that the PW, when PW asked as to why she had killed a person, she had replied that the appellant used to quarrel with her. In the cross-examination, the PW also stated that the deceased used to quarrel and cause ruckus under the influence of liquor. He also mentioned that the appellant seems to be a bit abnormal. Similarly, PW3, he also stated in his evidence that when the appellant was asked as to why he had killed her brother-in-law, she replied that she, being helpless, had hurt the deceased. The PW3 also, in the cross-examination, stated that the deceased Ghana Mohan used to cause ruckus under influence of liquor. From the above evidence, what perhaps appears is that the said deceased Ghana Mohan, under the influence of liquor, used to cause ruckus, and the appellant could have perhaps provoked or cause or do some activity which led to the aggressive behavior on the part of the appellant. Though the appellant has not made any specific plea in her defense as well as the statement recorded under 313, yet the aforesaid evidence of PW1, PW3 indicates the violent behavior and the nuisance, the capacity to cause nuisance by the appellant, by the deceased, cannot be totally ruled out. It is also on record that the said deceased was dancing all night during the Bihu festival by his own wife, PW4. Under the circumstances, we have the view that there is a distinct possibility also that the deceased was creating a nuisance in the house of the appellant, which made the appellant to strike him. This also, we find support in our taking this view, as the PW3 also stated that, clearly stated in his deposition that on being asked, the appellant accused replied that being helpless, she had hacked Ghana Mohan. The use of the expression being helpless, she had hacked Ghana, the deceased, perhaps indicates the position, indicates a situation where the appellant was driven to commit such an offense by the deceased. Under the circumstances, we are also the view that perhaps prosecution has not been able to establish beyond reasonable doubt one of the vital ingredients for constituting the offense of murder, 302 under IPC, that is the motive or the mens rea. As there is some element of doubt, as can be seen from the evidence of the prosecuting witness themselves. Under the circumstances, we are inclined to, we are inclined to convert the conviction of the appellant from 302, 304, which part?
Part 2.
Part two. And accordingly, sentence her to, and accordingly reduce the sentence also from life imprisonment to
Already see.
Minimum is 10 years.
how many?
Minimum is 10 years.
But
See, it's
how-
already cost 8 years,
8 years, reduce, no?
8.5 years.
8.5 years. To reduce to the period which, reduce, we are inclined to reduce, accordingly reduce the life sentence, reduce the life sentence awarded to her. It has been submitted before this court. Can you verify from the record that she is from 8.5 years?
Yes, I have seen it. She was produced from jail, she is still in jail. On the framing of Sergeant, she was in jail, she was produced from jail.
Even on conviction.
Yes.
Even on conviction, she was produced from the jail. Convicted and again sent back.
It has been brought to our record. It was brought to our notice. It has been brought to our notice that the appellant has been in custody since her
Since
date of arrest.
Yes.
From a date of arrest. A date of arrest.
Incident name. So she
And-
was given in.
When a date of arrest, what is the date of arrest? Can you tell us date of arrest?
23/5.
And remain under detention throughout the trial, throughout the investigation and trial, 23/5,
2014.
2014. And as such, she has undergone custody for,
8
More than
years.
8 years.
she has been in custody for,
More than 8 years.
More,
8.5 years.
Huh?
Up to May, it is 8 years. June, July, August, September, October, November, December. More than 8.5.
8
More-
years, 6 months. and
about
20 days.
about 8 years and
6
6 months. Under the circumstances, we are inclined to convert her sentence from life imprisonment to the period she has already undergone. So stop. According to the extent the appeal is allowed. The appellant accordingly may be released. Released and the release forthwith. That's all I think. Yes, and forthwith and we set a liberty forthwith. The High Court Legal Service Authority will give the honorarium to the learned amicus Mr. DP, Mr. Prashad at the rate fixed under the rules. I think for today, I think it's sufficient. Again.
Single bench is also
Single bench
there.
also there, na?
Single bench is there.
Oh, okay. Then